Okay, so you've all received the handout. You've all worked through and had a read for yourself of which of the different elements listed there are things where the law says you must do something, or where it says you can do something, or where it says you must not. You've either got a must, a can, or a not listed down each of those elements. Let me go through them all one by one. This is a summary of the law to the best of my knowledge. The first one is you must not disclose information that a client has given you except for the incidents listed here. That's a clear red. You must not disclose. In fact, I'll highlight that. You must not disclose information. The Privacy Act makes it very clear. Various other acts and our Code of Ethics all make it very clear. Things in general, by default, are kept confidential, with these exceptions. The first of those is a fairly obvious one. If you've got information that they have given you clear permission to disclose information, then you can disclose that. And any second now, I'll learn my technology. There we go. So that's a can. That's like an orange traffic light. You could do it. You could choose not to. It can go either way. I usually use this when I'm first introducing myself to the client. They're still trying to suss out whether they trust me or not. So I will introduce myself and say clearly, everything you say to me, with a couple of exceptions, is going to be kept confidential. In fact, we treat confidentiality so seriously around here that I won't even make a referral to another service. I won't give them any information at all about you unless you've given me your clear permission. I'll get you to actually write that down. Sign that you give me permission. That's how important it is. We lock up your information into a filing cabinet. We don't share it any further than that. Now, sometimes there'll be what we call team confidentiality. Team confidentiality is where it's shared amongst the people of your immediate team, in which case, again, when I first meet my client, I will make that very, very clear to them. It's either just between you and me, or it's just between me and my supervisor or the immediate team around me. Explain to them how far that goes. And again, explain it in terms of this is to help you. So I will share with people around me so that I can get better ideas. They've got good ideas and we want to give the best outcomes for you. Or if I'm sick, then you can still come in here and one of them will be able to read your stuff. Are you okay with that? Every now and then a client is not quite so sure, because they actually might be related or part of the same community as somebody else in the team. And then I'll call that member of the team in. So if I was working in a small town, a small Aboriginal or Vietnamese or some other nationality, a small community of some sort, there's a reasonable chance that they will actually know the person who's in your team. And you might need to convince them and have a bit of a chat with that person saying, yes, it will be kept confidential. Yes, they might be your uncle, but while any info they found out at work is going to be kept confidential. In some circumstances, you could talk to the boss and you could actually organise between you that staff member won't be told about that client if it's a particular concern of theirs. But again, this is all really giving your clients some really good messages about how seriously you take them and their opinion on things. Okay, the third one on your list. If somebody uses your service is reported as a missing person, it's a good idea to tell the police. You notice that's not saying you must. It's in fact saying you can. It's a good idea to tell the police that they're okay, but not tell the police or their family where they are without consent. If you're working with young people, it's especially a concern that their parents are going to have legal access to all this stuff. Generally speaking, no, they don't. If you're working with adolescents, no, they don't. Over 14, easy done. No, they've got no access. Under 14, check your agency policy, but generally speaking, they should be able to trust you that things will be kept confidential. This is different to what they might have experienced at school. Schools seem to think that they'll inform the parents about everything that happens. A kid goes to a teacher, says, I'm having troubles at home. The teacher contacts the school. So it's not necessarily what they've experienced elsewhere. but it often is. They're often very familiar with these systems. That's the missing person. Child protection, you must. There's a big fat must there. That's our first green. This is the first time we actually must report anything. In the ACT, you must report a child at risk of sexual or physical abuse if they're under 18, if you're a mandatory reporter. Mandatory reporter, mandated, means legally obliged to. Mandatory reporter means there's quite a list in each of the different states as to who is a mandatory reporter. The states make the rules around child protection, so it does vary from one place to the next. If you're working in Queanbeyan across the New South Wales border, you want to look up, it's a different threshold, it's significant risk, it's a much longer list. Here in the ACT, we're only talking sexual and physical abuse as legally mandated, legally required that you must. In New South Wales, it also includes neglect and psychological harm, emotional psychological harm, abuse. In the Northern Territory, everybody is a mandatory reporter, whether you work with kids or not. So the laws vary quite a significant amount from one state to the next. It's not consistent. You would need to check what the rule is where you're working. Now, here in the ACT, it's kind of odd. Mandatory reporter list includes the people you'd expect, medical workers, educational workers, childcare workers, all public servants. It doesn't actually specify in the Act that non-government services are going to have to report. I've asked my friends who work for non-government services, and they've said legally it might not be in the law, but it's in our funding brief that we have to have a policy that says all reports, all abuse notifications will happen. So I guess technically you're not breaking the law, you can't be locked up for it, but you could be sacked because it's an agency policy issue, not a legal one. Treat it as mandatory reporter for any risks of abuse in any service, and you'll be doing yourself a favour. Sorry? Check that link. I actually made a shorter URL. is.gd/ACT abuse. That gives you your full explanation. We can spend an entire unit talking about child protection, and I suspect you will at a later date. This is a quick summary, and the short answer is, as a mandatory reporter, as soon as practically possible is the answer to your question. As soon as reasonably, possible. Now that's mandated, that's legally obliged to, you gotta, for sexual or physical abuse. But every state also has a optional voluntary report. If you're not a mandatory reporter, that doesn't mean you're not allowed to report. It means you're not legally obliged to. So those two sort of go together, and that's where the agency policies can kick in and various other areas. But it's to do with information you found about through your job. So I work during the day at a childcare centre, I see bruises on a child, I'm legally obliged mandatory reporter. I go home, I see the same bruises on my next door neighbour's kid. That's not mandated, but that doesn't mean I'm not allowed to. That means it's a voluntary report. Check the link that I've given you. That's a very short summary. One thing you must do though is provide safety and wellbeing information if you're requested by Care and Protection. When they're doing their investigations, they want to request information so that they can suss out how safe the kid is and what they need to do to keep the kid safe. So again, when I'm explaining to my client, I'll make it very, very clear. One of the exceptions is if a kid is being hurt. If a kid is being abused, then I'm going to make a call. But it's tricky because this is very early on in your relationship with the client, and if you were to just blurt out, I'm going to make a report to docs, there's trigger words in there that aren't working for people, the JOCS or care and protection or making a report. So the wording that I would use is entirely accurate. I'm not suggesting you're dishonest at all, but the wording I'd use is, I will make a call to someone in order to keep that kid safe. And I'll explain, this is not in order to get you into trouble. I'd explain that this is in order to keep your kid safe. So my wording would be, I'm a mandatory reporter. That means legally I have to report abuse. But even if it wasn't the law, I'm not going to sleep well at night knowing that a kid isn't safe and I could have made a phone call to do that. So I'm going to make a phone call in order to keep that kid safe if they're being neglected or abused. And again, you'll notice I say neglected or abuse. You and I as workers know that neglect is a form of abuse. Our clients might not. We're putting this in plain, easy language for them to understand. We're saying if they are being neglected or abused, I'm going to make a call to keep them safe. I'm going to do whatever I can because I don't sleep well at night knowing I could have protected that kid. Or I don't like it when I read in the paper the next day that something as bad happened and I could have fixed it. That's the first of our things that we must report. Sometimes people think that because we have these confidentiality rules, they seem to think that they can't report any illegal activity, so that if somebody gets robbed on your workplace, they seem to think that they can't report that to the police. Yes, they can. That's different. We'll get to other crimes in a moment, but we generally keep illegal activity confidential. And that's a good thing to remind your clients of because it's often what they're scared of. So crimes at your agency, yeah, that's a can. You most definitely could report that. This is possibly the one that people got the most confused about. So let me be clear. Following up from our session on duty of care, you must disclose personal information to prevent or reduce a serious and imminent threat to the life or health of any person, whether that's a client or someone else. You have a duty of care to ensure that they are safe. So if a client is threatening suicide, if a client is saying I'm going to leave home and beat the crap out of somebody else who lives there, you can make a phone call, the police will get involved or the assessment team will get involved and they will make sure that that person isn't at risk of suicide, isn't going to be seriously hurt sometime soon. Or they're going to beat someone else up, or if they're going to go home and you're confident that they are going to get injured as well. If you can make that call. It has to be serious and imminent though. When we say serious, we're talking serious, we're not talking vague. Has to be maybe a life-threatening situation or one that could reasonably result in some other serious injury. And when we're talking imminent, we're saying it's about to happen, causing harm within a short period, within a few days. Weeks is a long time. Remember, you're calling the police to say, hey, this person is about to beat up his wife or about to get beaten up. It's not like the police are going to say when, the police will say when. If it's today, then they're going to go around. If it's sometime in the next couple of weeks, look, they'll go around and they have a chat. They might help put an AVO in order, but it's not like they've got infinite resources to park their car out the front, eating donuts all day, waiting for something bad to happen. The point of making the phone call is to prevent a serious and imminent injury. Probably an exception to that, one of the few that I can think of, is you might feel it's relevant to speak to the police if you know that your client owns a firearm or a firearms licence. You could speak to the police and say, I don't think that's a good idea. I don't think this person should have a firearms licence. Generally speaking, and that's not imminent, but that is, given their mental health state, sometime over the next weeks, bad things could happen. That's one of the rare exceptions I can think of where the phone call would actually make a difference. You're going to maintain your duty of care, but certainly you will mention it to your clients that along with child protection. And the wording that I normally use is, because I don't want to accuse any of my clients of, or what they might take as an accusation of them being suicidal or homicidal. So my terminology tends to be, I get all sorts of people, as you can imagine, coming in through that door there. Some of them are suicidal, some of them are violent and they're going to hurt themselves, or they're going to hurt someone else, or they're going to get hurt. Just like child protection, I'm going to make a phone call if I can prevent that from happening. So I do have a duty of care to make sure that if I can, I keep people safe. And throughout this whole discussion, I'm sort of saying, do you understand that? I'm checking out their body language, checking that they know what's going on. If they've got any concerns, I can usually pick it up by the way they look at me and that sort of thing. Okay, so imminent risk is something that's going to happen sometime soon. A couple of examples I've mentioned already: serious and imminent suicidal intentions, a drug overdose, or a serious threat to kill or seriously injure somebody. The drug overdose is interesting. Ambulance drivers, ambulance staff in general, hospital staff, they have a specific rule around overdoses, and that is that they will not call the police. They are not an arm of the police helping them gather information. People are sometimes scared to ring and get help because they're scared that, they're overdosing. They've clearly done something illegal, or they've drunk way too much and they're only 15. That's not how the hospital and ambulance system works. They would rather keep somebody safe, so they have a specific rule, policy that says we want to encourage people to stay alive, to get some help. Therefore, it's not our job. We won't be reporting to police. You overdose on something illegal, our concern is going to be keeping you alive. We won't be reporting that. So any chance you get to repeat that to your client group, not a bad thing. So I might want to mention overdoses as you're doing that introduction. And again, you're giving them some advice then. You're helping them out and helping them realise that you're trying to keep them safe. This can help with the trust building. Judge each situation individually. It's only for when it's likely to reduce the risk. The rest of the time, normal privacy. Point number 7, concealing an offence. This is a strange one because you can give information to the police that would help them arrest, prosecute, or convict someone guilty of a crime. In fact, legally, technically, can I just have a show of hands? How many people here are aware of somebody somewhere committing an offence at some point? Family members, someone in your class, somebody in your neighbourhood, somebody you know. Show of hands. Gee, lots of you have really straight friends. Okay, now keep your hands up. Keep your hands up. Now leave your hand up if you also reported that to the police every time. Okay, so all of those who pulled your hand down then were actually acting illegally by helping conceal that crime, and I should probably report you all. That's not going to happen. We know that technically that's a technicality. It's very rarely used. Sometimes police will threaten that. They've taken a young bloke in, he's clearly scared, and they've said, if you're holding back on me, if you're not dobbing your mates in, then you're breaking the law, dude. They probably won't say dude. But that's about the only time that's really used. We understand, as most of this class did, we hear about illegal stuff. You should be giving that information unless you have a reasonable excuse. As a welfare worker, you've actually got an even better reasonable excuse. You can't work with your clients, you can't build trust with them unless you keep things confidential. So that's our reasonable excuse. I know only of one organisation that sometimes has this rule. Yeah, 2 organisations. Juvenile justice and corrections officers may have a rule that says anything I hear about where you're acting illegally, I'll need to report that. They should make that really clear. Because that's the point of this exercise, is We know what we need to keep confidential, and our clients know what they can tell you and what they can't without that being kept confidential. PCYCs originated as police after hours, helping out disadvantaged boys in their neighbourhood. Some of them still have that to varying degrees. Most of them have employed youth workers, but some of them still have police after hours. You don't confess your crimes to a cop and expect them to just ignore it. You can mention it to your youth worker. It gets very difficult in very few, but some PCYCs where cops are indistinguishable from the youth worker. So if you, nothing in the ACT, nothing in most New South Wales, but there are some where the police will be there. Ideally, they would be in a uniform of some sort. They'd be making it very clear, I'm here as a cop, if they're going to have these sorts of conversations with young people. That's the only time. So although it's coloured in yellow, generally speaking, illegal stuff is kept entirely confidential. So I'd emphasise that to my clients. I'd say, be aware, I hear about illegal stuff all the time. Smoke a bit of pot, drink underage, whatever, that's going to be kept confidential. However, point 8 says something slightly different. So I would immediately follow up with, there is a limit to how much I can keep confidential. If it's a serious crime, obviously a murder, I'm not going to keep confidential. Something serious like armed robbery, if you're shoplifting, I'm going to keep that confidential. If you're part of an organised group, shoplifting on a regular basis, for profit in an organised manner, then there's limits to how much I can keep confidential. Organised crime would be one of them. So think about it as to how much you want to tell me. I have heard about my clients stealing cars on occasion. We kept it confidential. We worked with those clients. If they are part of an organised ring, stealing cars for parts to be chopped and so on, that would be getting into the organised crime element. And again, I'd choose examples that I think might fit with my client group. I'm a youth worker by trade, therefore I tend to think of a lot of my clients. I'll explain to them that underage drinking, it's not a serious crime. I know you're worried about it, I know you might, it's not. Underage sex, seriously, 2 consenting teenagers, it's not that serious. That's not the sort of thing I'm talking about. I'm talking organised crime. I'm talking about armed robbery. So emphasise that we keep illegal stuff confidential. Don't emphasise the exceptions, emphasise the illegal is confidential. If there's a crime, I didn't mention, if there's a crime that hasn't happened yet, unless it's a duty of care issue, there's no obligation to report that. I have been in a car when I was younger with friends and friends of those friends. This is not as a worker. The friends of the friends immediately started trying to sell me large quantities of drugs, and they stopped off at a bottle shop and were clearly scoping out whether they were going to rob the place or not. Had I been a worker at the time, I would have had to say to them, I'm not under any obligation to report what I just saw, but if you rob the liquor store, then that's serious crime. I'm sort of obliged then, so might be best not to, if that's what you're thinking. Maybe you're just, looking at the windows and the locks on the doors, as a hobby or something, but there's no need for me to report it. But if the crime happens, I'm then aware of a serious crime. That's that part. Next section is subpoena, very conveniently spelt difficultly. Subpoena. It's a document telling that you must go to court to be a witness or to produce something to the court. If you're hit with a subpoena, you do have a choice to not hand it over. You are free to be locked up by them and taken immediately to jail, because that's your only choice. You either hand it over or they will take you away. And somebody else will hand over the files instead. Don't try to escape a subpoena. If you're particularly concerned, there's been cases in the past where people maliciously subpoenaed the files of their ex-partner going to a sexual assault counsellor. Pure malice, pure malicious intent with all of that. Laws have tightened up on that sort of behaviour, but using that as an example, if it's papers that you are particularly concerned that you don't think should be presented to the court, stick them in an envelope, write a note to the judge on it and say, here's my concerns, and hand them over. Subpoenas only ever happened to me once in my whole career, to my people I'm close to. Networking, I can think of 2, maybe 3 cases in the last 30 years where, and in fact all of them have been cases where it's the worker has been investigated for their abuse of clients, and they're subpoenaing and they're wanting evidence against or for that worker or for the protection of the clients. And in fact it's quite a respectful process they go through, because the defendant's lawyer gets to look at stuff and say whether it's relevant to the case or not, and the police lawyer gets to look at it, and they get to choose between them which are actually truly relevant to the case. If they don't agree, it goes to the judge, who will say yes it is or no it isn't. So the actual defendant, either party, is not going to see it. Their lawyers are going to screen it. So an associate had a worker at her service who had been hurting kids, and all of the files got subpoenaed for that service every time he was on shift. She went to a bit of effort, but it turned out that's what the lawyers were doing, is to say the relevant part, because we're out to prosecute that worker for what he did with kids. So the rest of the notes might mention that the kids were taking drugs, or the kids were stealing stuff, or the kids were whatever. They were making a point to not include those because they weren't relevant to the prosecution. It wasn't a chance for the police prosecutor to gather all sorts of other info having done that. The lawyers screened all of that on both sides. If you receive a subpoena, tell your management committee immediately. Contact anybody whose privacy might be breached by the subpoena. So ring your client up and say, hey, just letting you know, police have just come and taken, the court has just taken, officers of the court have just come, taken our files, it's been subpoenaed for a case, and let them know how much detail we're talking about, and immediately get some legal advice. Community legal centres are quite good to negotiating the protection of your client's privacy. Point number 10. As red, if I could do this in a darker shade of red, then I would. You must not disclose anybody's HIV status. You must take reasonable steps to prevent that disclosure. Not letting other people know if somebody has had an HIV test, let alone what the results of the test were, and not recording that down unless it's... I can't think of cases where that would be relevant to your work. You're not at risk of contracting HIV from your clients unless perhaps you're sleeping with them or sharing needles or very few other things. When HIV, AIDS as it was back then, I hadn't discovered the virus, in the early 90s when it was first occurring in Australia, there was a lot of panic and hysteria around this disease. And as a result of that, there were very tight restrictions placed on how things should be disseminated. So in the ACT, generally, in most states, there's very, very tight rules around what can be disclosed. You're not going to be telling. If you've got team confidentiality happening, you're not telling the rest of your team about it. If they have an HIV test, you're not telling the rest of the team about it. That's very clear there. In the ACT though, when I moved here from interstate, I checked up the laws and I did find that doctors, nurses, social workers, psychologists do need to report to the Department of Health, as do a person who's responsible for the care, support or education of somebody. That's us. We would need to report it to a specific bunch of people in the Department of Health who are trying to stop diseases from spreading. This is actually any notifiable disease. This is not just HIV/AIDS. This is hepatitis, chlamydia, quite a list. That's information that should be, and it's very clearly saying, it must be very, very well protected. It should only go to the Chief Health Officer of the person that you believe may have that notifiable condition. I might actually just pull that up for you. The code of practice is there. I can just quickly, you can search that if you like. This actually, code of practice clearly says that this is not for, it's for doctors, nurses, psychologists. It's not for the person protecting blah, blah, blah. However, I spoke to that bunch from Department of Health and asked them, okay, so what are the rest of us supposed to do? And although, as I said, it clearly says that this is for these people, medical practitioners, nurses and pathologists, and it's not for all of us. The code of practice is being rewritten to include all of us, and I said basically just follow this code of practice anyway. Really what it's saying is ring them up and they'll work it out. What I wanted to draw your attention to is just how seriously they take this. So malaria, measles, you'll see a whole list of different, leprosy, the plague, all sorts of different diseases they should be told about. Ring them on the number, the surveillance officer of the communicable disease control section. Any of these diseases, just give me a moment. The part that I'm looking for is right here. Family name and given name of the client. You can just give for certain diseases such as HIV and hepatitis just the first two letters of the first name and last name. Even on their forms, they're suggesting that you've got the freedom to just give part of the name. That is how tightly it is controlled. They will be able to work it out from the postcode, first two of this name, first two of that, if this is somebody they already have on their list. That's what they do. They're very good at this stuff. They don't let it leak out. If you're concerned that your client, who you for some reason know is HIV positive, is, what shall we say, maliciously or carelessly sleeping around, they will probably want to know about it. They will have a record because the doctors will have reported it to them. It's not your job. In fact, it's specifically stated in the Act. It is not your job to tell the partner. Your job is just to speak to that mob. They deal with it. That's their job. They may well take that person in for counselling or for a criminal act, but that's their job, not yours, to chase up on that one. The Notifiable Conditions Code of Practice spells out who to contact and when. I just gave you a quick look at it. I can't promise you there aren't any other laws about Centrelink or immigration or terrorism. I've done my best to give you all of the gaps. But if we take a look, and sorry, I certainly think you should read in more depth the information from Yappa or down the bottom, the Shopfront. It's a beautiful website, but it's New South Wales based. But they go into a bit of detail and explain quite clearly how privacy and confidentiality for youth workers, it is a youth service, should be working. Just taking a look at that, let's zoom out. There's only a couple of cases where we have to report. There's only a few greens there. Child protection, serious and imminent risk of harm, serious crimes and subpoenas. That's 4. 5 if you want to include team confidentiality. Your job is going to be knowing the law well enough to explain it, not just to blurt it out, not just to hand a piece of paper to them from the sign, but to know those 4 or 5, depending on how you count it, exceptions, and say that in a respectful manner to your clients so they understand how much they can share with you and how much they can't. On the second page of that handout, I've made a spreadsheet that gives a bit of a flow chart there as to simplifying it all. Feel free to use that. Be aware that it's a summary of my best understanding, but basically I need you to know those four, or if your agency policy is something that includes one of these yellow spaces as well. If you've got an agency policy that says we'll always report missing persons and we will disclose, then you need to explain that to your client. That is your assessment task. That is your job.